have everybody, so let's let them in. I think we have everyone. Good morning. I'm going to call the matter. This is the time set for a status conference in CV 2017-055490. For plaintiff, please announce. Well, I don't hear anybody announcing for plaintiff, but I see Mr. Eastin's name. Let me see if Mr. Casavelli or Ms. Castelli are on the line. Mr. Casavelli, are you on the phone?
Yes, Judge, we are.
Okay. Okay, thank you very much. And Mr. Eastin, are you able to communicate yet?
Yes, I am, Your Honor. I'm sorry, I had my mic muted.
That's okay. All right. So we do have everybody. There's a couple things. There was a remand from the Court of Appeals. I just want to modify but affirm my ruling, finding Mr. Casavelli and Ms. Castelli are vexatious litigants, but only as to this case. It is not an absolute bar with respect to the court, but it does set a record for future filings that is a potential risk. But I want to just make it clear that that is the finding the court is making. We also have pending a number of things. I wanted to identify what's still pending right now. I do have and ready for argument, and there's been more than enough time for briefing on the renewed motion for a protective order. I received that. I received the response. I received the reply. So I'm ready for argument on that because that is fully briefed. So let's discuss that. Mr. Eastin, this is your motion. Go ahead.
This is the renewed motion, Your Honor?
Yes, this is the renewed motion.
Thank you. Just, Your Honor, the court has stated repeatedly that discovery was closed except for the taking of Ms. Johansson's deposition, and then the defendants did not comply with the court's orders about the taking of that deposition, so the court found a waiver. We believe that all discovery is closed and that the court means what it says when it says that discovery is closed. The defendants seem to think that the court's orders are suggestions that they can take if they choose to take them and ignore them if they choose to ignore them.
Please put words in our mouth.
So we're asking for the court to just reiterate however they need to the defendants that discovery is closed, and that means closed for all purposes. They do not need to take they've had plenty of time if they wanted to take the deposition, do a 30B6 deposition of Garpton. They had plenty of time in the 4 years before this to do so, and they never noticed that out, not even one time. And what this appears to be is simply an attempt to circumvent the court's order that said that Donna's deposition was waived. In fact, the same day that the court issued the order that Donna's deposition had been deemed waived is the same day that they issued their Rule 30B6. So it was a clear attempt by them to circumvent this court's order that her deposition was over and done with, and it was in defiance of the order. They do make in their reply they do assert a couple different things. They assert that pardon me, Your Honor, let me get to something here. They seem to assert that nowhere in the rules is it permitted to, or does it say that discovery is closed. But there are numerous rules which give the court the authority to do that. The court is well aware of those, of its own authority and its jurisdiction to control discovery. And cited in my reply are various rules should the court wish to reference those. And then finally, they seem to apply, or they assert that Rule 26D applies here. We filed under Rule 26C, so we don't think that a good faith certificate is necessary in this regard. Certainly, this is just a clear violation of the court's orders. They have not shown any good cause. They have not shown any good cause or reason why they could not take Garpton's deposition any time in the last 4 years. All this is further attempts to harass, delay, run up the costs, make things more difficult So we would ask the court to deny their attempted 30B6 deposition of Garpton LLC.
All right, Mr. Casavelli or Ms. Castelli, you want to respond?
Sure. My first question is, how is the court doing this when there hasn't been a remand from the appellate court to start with? I want to make sure that's on the record. Second is, how is Mr. Eastin representing Garpton LLC when they're not a litigant party and he doesn't represent Garpton? Representing a member would be representing Garpton. He represents Donna Johansson in her individual capacity. So him requesting a protective order for Garpton is not allowed by the rules. He says that we've had time to obtain Donna Johansson's deposition in the last 4.5 years. Every discovery attempt we have made, he has blocked, he has opposed, to the point of qualifying underneath vexatious litigant, but only because he's an attorney. The Arizona law doesn't apply to him. But we haven't had time. Everything. Review of the record, 471 documents. He has blocked every request for discovery, any type of thing whatsoever when it comes to discovery, he has opposed. In the last 3 years, he's gotten every wish he's ever had vetted by the court. And now he's stepping over the line by asking the court to violate known and established laws when it comes to him representing Garpton, and Garpton's not a litigant party, and Garpton is not his client, because I am Garpton's agent still, currently. And I know he doesn't represent Garpton in this matter. And it's a clear violation and a conflict of interest. And any ruling this court would do would be violating known and established laws, granting a protective order for Garpton or anything related to Garpton without them being a joined party.
Which he refused.
Now, he says that this protective order he's filing under Rule 26C. Well, the law is pretty clear on 26C that it's for confidential documents and it's only allowed to prevent embarrassment, harassment, or things as such. But he's just generally asking for a protective order for a party that he has no representation rights and basically practicing law unauthorized. So he may be licensed to practice law, but he doesn't have the ability, or the law doesn't support him representing someone that's not his client and who hasn't retained him. And for him to argue a matter of success or interest is ridiculous, because a member of an LLC cannot assign interest to themselves because they have to become a member if they do such, and they don't have any membership rights if the assignment is there. A member can assign interest to anyone else, but his interpretation of the law is wrong. And if the court rules in his favor, then the court is going to be wrong. And as we've been told, the court is presumed to know the law. And that's where we stand with this. He has stepped out of his bounds because he doesn't want the information produced throughout this litigation to be submitted as evidence at the trial, because it's damaging for him. And he's just attempting to use the court to remove that evidence that's condemning. And his protective order should be denied for those reasons.
All right. Before I turn to you, Mr. Eastin, Mr. Casavelli, I don't know if you received it. I'm looking at it right now. I received it maybe yesterday. It could have been the day before, that the Court of Appeals declined jurisdiction on the special action. You might not have received that yet, but I wanted to let you know that. Mr. Eastin, can you rebut the argument?
Sure,
Judge.
Wait, no, I'm going to hear Mr. Easton's response now. Go ahead, Mr. Easton.
Special action, Judge.
That's okay. Okay, I'll deal with that after I hear from Mr. Easton. Go ahead, Mr. Easton.
Sure, Your Honor. Rule 26C allows any party to file a protective order or any person from whom discovery is sought. The plaintiffs are a party in this case. They're allowed to file for a protective order Garpdon does not need to come in here and request it separately. So that argument, I believe, is irrelevant.
You need to check the laws, Mr. Eastin. You need to reread the laws because you're wrong.
Go ahead, Mr. Eastin.
So they brought up another point at the beginning of Mr. Casavelli's argument, and I forget what it was exactly. I don't know if it had anything to do with the fact that he's claiming that the court doesn't have jurisdiction now. I know he's raised that at some point somewhere. The remand that the court received, there has not been a mandate issued yet, and the defendants did petition for review to the Supreme Court of Arizona. So there may be a mandate in place. If it is, then the vexatious litigant order may or may not be able to be addressed here today or not. But
okay, fair enough. But it does not mean I can't handle other substantive matters. So
I agree with that.
Okay, so with respect to the fact that the vexatious litigant findings may be on appeal, I'll just note that in my minute entry that is, I understand what the Court of Appeals is trying to direct me to do. If Mr. Casavelli and Ms. Castelli have appealed that, they have a right to do that. So I won't take any further action until a mandate issues.
Right.
Go ahead.
And
just the court, we intend to file a writ for certiorari as well.
Okay, that's fine. You have a right to do that, but let me hear Mr. Easton's final bit of his rebuttal argument. Go ahead.
Well, just in regard to that, Your Honor, I think that the court does have the right to proceed on ministerial functions while an appeal is pending. I don't believe that there's anything.
I agree. I am allowed to do that, and so I will continue to do that, but obviously the vexatious litigant finding can't be finalized yet until all appellate relief is finalized. So go ahead, Mr. Easton.
Yeah, I just brought that up, Your Honor, too, just to say that if there's any kind of stay on the court, then that stay applies. I don't think they have the right to file this 30B6 subpoena to Garpdon, but if they're not acting consistently, if they're saying that if there's a stay in place in regards to an appeal, then they don't have the right to conduct discovery.
It's not up on the table.
So
we haven't had a chance to address any motions by this judge
Right now, I originally had set this as a status conference on the Court of Appeals vexatious litigant. Other motions were filed. So either the parties can stipulate to a stay of consideration of any pending motions, or I'm going to move forward not on the vexatious litigant, but on some of the motions that are pending. They're unrelated to the vexatious litigant issue.
The court doesn't have jurisdiction on this issue, and they're moving on issuing any orders at this point in time.
Okay,
because the vexatious litigant affects all of these orders.
Thank you. Mr. Easton, what's your position on that? Mr. Easton, Mr. Casavelli, please don't interrupt. Mr. Easton, do you want me to simply stay consideration of all pending motions until the appellate courts have finished considering the vexatious litigant issue? All the vexatious litigant issue does is either stop the filings in this case or be allowed to be extended to court-wide filings. But Mr. Easton, what's your position?
No, Your Honor, we'd like to have you go ahead and rule on the pending motions that are in front of the court.
Okay, well, the only motion that would currently be ripe for consideration that's fully briefed is the protective order motion. There are other pending motions that are not fully briefed. There's a motion to disqualify. There's a motion to order joinder of required parties. And there's also the motion for stay. So I recognize there are other motions. I'm not going to consider them today in any event because, again, they're not fully briefed and ripe for consideration. So the only one that's ripe for consideration would be this motion we're discussing.
Agreed, Your Honor.
Okay.
Disagree, Your Honor.
Okay.
Disagree, because the vexatious litigant has a bearing on all motions here filed in this court, and has been. And until there's a complete ruling on that, we don't feel that the court has jurisdiction to rule on anything other than this, other than set and status conferences and things of that, because this is deciding issues of discovery and things that will affect trial.
Okay. You know, what I'm going to do at this point in time is take no action with any pending motion, including the protective order one, which also means that motion cannot be pursued, meaning the 36B deposition cannot be pursued at this time. So all parties will just maintain the status quo until the Arizona Supreme Court rules. And I'm simply not taking any action, but I've identified the pending motions, so let me review. The pending motions are the renewed motion for a protective order, the motion to disqualify, the motion to order joinder, the motion to stay. Okay? And those will continue to be pending, and we'll be at recess on this matter. Thank you.
Thank you, Your Honor.